everybody. Oh, perhaps some of you are places where it's not morning anymore, like my daughter in Shanghai. I want to welcome everybody to the program today. I'm Joan Churchill, a retired judge on the Immigration Court. I'm a member of the Empty Nesters group at Washington Hebrew, and we're bringing you this program as part of our Inside the Issues activities. We're doing it by Zoom, which is a wonderful, wonderful method to get a lot of people together. I'm coming to you today from my beach house in Rehoboth Beach. We made the front page of I think both the New York Times and the Washington Post last week when an airplane strayed into restricted airspace while the president was here. It's kind of exciting to have a beach house here. And Zoom is wonderful because, as I mentioned, we can have people from all over the world attending. My daughter, Rebecca, is attending from Shanghai, China, where she's a teacher. Professor Rosen is a person who divides his time, I believe, between both Philadelphia and Washington, D.C. Jeffrey Rosen is an eminent scholar of the Constitution. He is the president and CEO, in fact, of the National Constitution Center in Philadelphia. Our Empty Nester group actually made a trip to the Constitution Center about a dozen years ago. And Sharon Farber was the first person to click on today, and she helped us arrange that trip. Her son-in-law was the president at that time. So thank you, Sharon. And thank you to Professor Rosen for joining us today. Where are you today, Professor Rosen? Are you in Philadelphia or Washington, D.C.?
I'm here in Cleveland Park in my house in Washington, but I have as my fake backdrop the beautiful First Amendment tablet at the National Constitution Center, so I can be in both places at the same time.
Oh, that's fantastic. Isn't Zoom wonderful that way?
It is.
All right. He's a professor of constitutional law at George Washington University Law School. And he's written quite a number of books and articles. He's a contributing editor of the Atlantic magazine. He was previously a legal affairs editor of the New Republic and the staff writer for the New Yorker. I believe your most recent book is the book Conversations with Ruth Bader Ginsburg, well, RBG you called it, Justice Ruth Bader Ginsburg, and then there's a bit of alliteration on life, love, liberty, and law. He's also written biographies of William Howard Taft and Louis Brandeis, both of whom I believe were on the Supreme Court. Is that right? Yeah. President Taft was on the Supreme Court after being president, right?
Right.
Professor Rosen is a graduate of Harvard College, Oxford University, where he was a Marshall Scholar, and Yale Law School. He's going to speak to us today for about 45 minutes, and then we'll take questions from the chat at the end of his remarks. With that introduction, let me turn it over to you, Professor Rosen, for your talk about the Supreme Court today. What's next?
Well, thank you so much, Judge. And hello, friends. It is wonderful to talk to you. I was delighted when Judge Churchill reached out. I do split my time between Philly and DC, but my home has been in Cleveland Park for many years, for more than 30 years, ever since I left law school. And I pass Washington Hebrew congregation frequently, and I'm just so glad to connect with this great community. You have asked me to talk about the future of the Supreme Court at a remarkably challenging and important time, to put it mildly. As we all know, the court, by the end of the month, is likely to hand down landmark decisions involving abortion as well as guns and religion, and debates over the court's legitimacy have never been more heated, at least since the 1930s, when there was also talk of court packing in the air. I am delighted to talk to you in the spirit of all of the teaching and learning that we do together at the National Constitution Center, where I always begin our programs by reciting the Constitution Center's mission statement, which comes from Congress, which created the Constitution Center during the bicentennial of the Constitution. I'm going to do the same thing because I think it'll be helpful to put us all in a nonpartisan spirit of learning together, which is especially important at this fraught time. So the Constitution's mission statement says, the National Constitution Center is the only institution in America chartered by Congress to increase awareness and understanding of the Constitution among the American people on a nonpartisan basis. And friends, it is so important during this very challenging and polarized time for each of us and each of you to make decisions about the decisions that the court is handing down by making up your own minds. And that requires educating yourself about the complicated constitutional arguments on all sides of the very difficult issues that the court is deciding, and evaluating them in constitutional and not political terms. In other words, what I'm asking you to do, and what I'll talk to you about today, is the importance when you're looking at the decisions involving abortion and guns and religion, not of asking what you think the government should do when it comes to those very important issues, but what the Constitution allows or forbids it to do. And open yourself up to the possibility that you might reach a constitutional conclusion that differs from your political views. In other words, you might think that the right to choose is an urgently important right for women to have, but it's not contained in the Constitution. Or you might conversely think that, you know, that you might be pro-life and think that women shouldn't have that right, but that the Constitution does guarantee it. And by opening yourself up to the possibility of reaching constitutional decisions that differ from your political views, you'll be thinking the way judges are supposed to think and elevating yourselves as citizens. And you'll also have to learn a lot because these are really complicated questions. To have an informed opinion, you have to read the text of the Constitution, read what the Supreme Court said before, read the paradigm cases that gave rise to the provision, and then make some hard judgments about precedent. You have to kind of think like constitutional lawyers. It's difficult, but very rewarding, and I think you'll find it elevating. So I'll talk through with you the arguments on both sides of, let's say, the abortion and guns cases, because those are the big ones. And we can have a discussion about those and anything else you like. But before I do that, I wanted to step back and talk about the context in which these decisions are arising. And in particular, talk about a conversation that I had with Chief Justice John Roberts at the beginning of his term in 2006. He had just begun his term as Chief Justice, and I was writing a book about the Supreme Court for PBS, which was running a series on the Supreme Court. The book in the series had the incredibly creative and provocative title, The Supreme Court. Chief Justice Roberts is a PBS fan, so he agreed to talk to me for the book. And we published the conversation both in the book and in the Atlantic magazine. And during our conversation, he expressed concern with the polarization in the country and noted that the president and Congress were very polarized, and red and blue America seemed to be polarized. And he said that he thought it was bad for the court and bad for the country when people thought of the justices as politicians in robes and assumed that Republican justices would reach one result and Democrats the other. He said he would make it his mission as Chief Justice to persuade his colleagues to converge around narrow, unanimous opinions that avoided contested constitutional issues in order to preserve the legitimacy of the court and to help citizens see it as a nonpartisan body. And he cited as his model his greatest predecessor, Chief Justice John Marshall. Marshall, he noted, came to the court at a time when it was vulnerable and not very powerful. Chief Jefferson, who mistrusted Marshall, who was his distant cousin, threatened to ignore the court's decisions. It was so unprestigious that people kept turning down the chief justiceship or resigning from it to run for other things, the way John Jay and Rutledge and the first chief justices did. Basically, no one wanted the job. And Marshall converted the court from one of the weakest and most overlooked branches of government to the head of one of the strongest and most co-equal ones, partly by the force of his constitutional vision, which was based in strong national government and the importance of union, and also the force of his personality. He persuaded his colleagues to live together in the same boarding house on F Street. The building, I think, is now on the GW campus, although I'm not sure the original survives, but the address does. And the justices would discuss cases over a hogshead of Madeira, which was Marshall's favorite drink. And all the justices would get buzzed, and all the cases were unanimous, Roberts noted. There was one moment when the justices voted to drink Madeira only when it rained. So Marshall looks out the window and says, our jurisdiction is so broad, it must be raining somewhere, but more Madeira, more unanimity. So Roberts said, look, I'm not naive. I understand that this is a more polarized time, although the election of 1800 was extraordinarily polarized as well. And it may take more than Madeira, but I'm going to try to persuade my colleagues that it's in everyone's interest to be in the majority 100% of the time or 90% of the time by embracing a narrow result rather than flipping a coin and risking being in the minority. Plus, I think it'll be good for the court. And he said, you know, who knows if this is going to work? If it doesn't, we'll try something else. But I think this is important. All right, friends, I think that Roberts's vision was an admirable one. I'm not allowed to have opinions about particular constitutional issues now that I'm the head of the Constitution Center because we're nonpartisan, but as a matter of shoring up the institutional legitimacy of the courts, which is something very much in our bailiwick, I'm on Roberts' side on this one. I think I agree that it's important for citizens to perceive the courts and for the courts, in fact, to behave as nonpartisan actors and for their legitimacy to be preserved. For the same reason that Justice Breyer just gave when he talked about the urgent importance of citizens embracing the nonpartisan legitimacy of the court. Breyer said, if people don't recognize the courts as nonpartisan actors, and unless they're willing to obey decisions that they disagree with, then we're like Russia. The difference between us and Russia, Breyer suggested, is not our constitution. Russia has a beautiful constitution. It has a Bill of Rights, but its Bill of Rights and its constitution are a lie. They're meaningless because in Russia, one person has all the power and he can change the laws and he can bend them to his will and he can wickedly pursue his own rapacious interests, unconstrained by other branches. By contrast, the central innovation of the American system, this is not Breyer, but this is what I believe to be true, and is in the Federalist Papers, is the separation of powers. It's the fact that the president's not the king, that the courts are not the king, that the Congress isn't. We, the people, are sovereign, and we parcel out our power to different branches of government who can stop each other from consolidating their power and threatening liberty. The courts are a crucial part of that. And unless the courts both are perceived of and are independent actors, embraced as such by the citizens, then they can't stop the president when he tries to take too much power or stop the Congress or maintain liberty. So that's why this is not a joke, the topic of our conversation, the question of whether the courts maintain their legitimacy as nonpartisan actors. And that's why I think Roberts has been correct to try to pursue this vision. Now, he's had what we would have to call mixed success in achieving it since 2006. As he recognized, his success is dependent on his colleagues' willingness to embrace his vision. After all, he has only one vote as Chief Justice. His only power, as he told me, is to assign the majority opinion when he's in the majority, or give it to the justice who best reflects his views. When he's in the minority, then the senior associate justice in the majority assigns the opinion. That's what seems to have happened in Dobbs. According to press reports, Roberts, initially, Chief Justice Roberts took the opinion for himself and tried to write a draft that upheld the law in question with the 16-week ban, but upheld Roe as well, did not overturn Roe. But he didn't get 5 justices to go along with him. And at some point, Justice Thomas seems to have suggested, you don't have the votes. I'm the senior associate in the majority. I get to assign the decision. And he seems to have assigned it to Justice Alito. These are according to press reports, which is a plausible account of what happened. Of course, but just to review Roberts' record of success, his most notable example of casting a vote to preserve institutional legitimacy was upholding the Affordable Care Act, where he initially voted to strike it down, but then decided it would be in the institutional legitimacy of the court's interest to uphold it as a tax rather than under the commerce power. And that's what he did. And there have been a series of other decisions where he joined the more liberal justices, including in the Hellerstedt abortion clinic decision, for a result that he had initially opposed because he thought it was not good to have big shifts to the law imposed by newly appointed justices, all of the same political party, because the court would appear to be political. That was Roberts' vision. He was relatively successful. He had mixed success in achieving it when Justice Kennedy was the swing vote. His success broadly depended on whether Justice Kennedy was willing to go along. And Justice Kennedy tended to like sweeping and broad decisions rather than narrow ones. So Chief Justice Roberts wasn't always successful. The most notable example of this is the Citizens United case, where Chief Justice Roberts had initially wanted to embrace a narrower opinion that would have allowed the speech in question, which was an anti-Hillary Clinton documentary, but not completely held that corporate speech has the same standing as non-corporate speech. But Kennedy didn't want to go along with it because he liked sweeping defenses of the First Amendment, and therefore Roberts, was forced to let Kennedy define the terms of the opinion. Now, all this helps us understand how significant the appointment of Justice Barrett was when Justice Ginsburg passed away, because Roberts lost his ability to control the majority in these cases, as Dobbs shows. And once he's no longer the swing and the median vote, during that one term, I guess it was the 20 term, the term that began in 20, he was in the majority more than any other justice, and Adam Liptak in the Times called him the most powerful chief since Charles Evans Hughes during the New Deal, because he was both the chief and the median justice, and as a result was able to control the opinions in most important cases. Once Justice Barrett joined, he lost that power. And he may have a vision of institutional legitimacy, but if there are 5 justices who are not going along with him, he wants to preserve Roe and come up with a compromise. If he doesn't have 5 votes, then he can't do that. Now, some reports said he was trying to peel off Justice Kavanaugh, and that the leak may have been an effort by either side, but some have suggested the conservative side might have had a big incentive to do it, to lock Justice Kavanaugh in, to ensure that he didn't change his vote from his initial position by publicizing the fact that he had initially joined Dobbs. Others suggest it was a liberal clerk. Now there's an investigation by the FBI, or rather by the court clerk. And the clerks are upset because they've been asked to turn over their cell phones, and it's not a good atmosphere at the court. I was there for a judicial conference a few weeks ago, just as the barricades were going up, and you can see the barricades from the outside. It's when you're inside, obviously you feel like you're barricaded in, and this is a striking, unfortunate moment for the court when it's got to put up barricades against the American people. So this is a serious time. Back to Dobbs. I think now is the time for me to quickly summarize the constitutional as well as prudential arguments for and against upholding Roe, which I imagine will be in the final decision. If a version of the Alito leak becomes the majority, then there's going to be quite a extraordinarily vigorous dissent or series of dissents by Justices Breyer, Kagan, and Sotomayor. And let me describe to you what I imagine, because this is not hard to imagine, what the arguments for and against upholding Roe would be. The argument in favor of overturning Roe is the one that's in Justice Alito's draft. And what I want you to do for now, for a moment, as I'm describing this, is if you're pro-choice, to listen to these arguments in an open spirit. See if you're, I'm going to give the best argument I can. And Alito, it's not a complicated argument. He kind of makes it in the draft. Just listen to the argument, and then I'll give the arguments against, and then you can decide what you think is right. And I'll also note that there are pro-choice scholars, like my great teacher in law school, Akhil Amar, who just wrote an op-ed for the Wall Street Journal saying, I'm pro-choice, but I think Alito was correct. So it's possible for you to be pro-choice and think Alito was correct, or you can be pro-life and think Alito was wrong. But I'm going to just give you the constitutional argument. Here's the gist of Justice Alito's argument, that if first, is there a right to choose abortion in the Constitution? Justice Alito says, obviously, the Constitution doesn't contain the word abortion, and that in deciding whether or not the Constitution protects a liberty that's not specifically enumerated under the due process clause of the 14th Amendment, which says no state shall deprive any person of life, liberty, or property without due process of law, the correct approach to figuring out which liberties are protected is history and tradition. And Justice Alito says we should look at history and tradition at a relatively narrow and modest level of generality. He's taking this from a case involving the right to die, the right to choose assisted suicide, called the Glucksberg case, which says, look to what the states have done over the course of American history. And if the overwhelming state practice supports a particular unenumerated right, then the court may decide that it is protected. If not, it's not. And Justice Alito says, when it comes to the history, although practice was varied from the time of the founding until about 1850, in the mid-1850s, states began passing very restrictive abortion laws. And by 1868, which is when the 14th Amendment was ratified, almost all the states banned abortion throughout pregnancy from the moment of conception and had few exceptions. And in 1973, when Roe was decided, most of those laws were still on the books. Therefore, because the majority of states from 1850 or from 1868, when the 14th Amendment was ratified, until 1973, when Roe was decided, generally banned abortion throughout pregnancy. There is no tradition of protecting abortion throughout pregnancy, and therefore the Constitution doesn't protect such a right. That's the basic constitutional argument against there being a right to abortion. And then Alito confronted the question about what about precedent? The court, after all, not only found a right to abortion in Roe, but reaffirmed Roe 6 times since 1973, most notably in 1992 in the Casey decision, when Justices Kennedy, O'Connor, and Souter, all appointed by Republican presidents, joined the liberal justices in affirming Roe. And in doing so, they talked about the urgent importance of stare decisis, or let the decision stand, or precedent. And those justices gave several reasons for why Roe should be overturned, even if it was wrong as an original matter, including first, the fact that the decision is workable, it articulates a clear standard. Second, that there haven't been changed facts that have called it into question. And third, reliance. Women have structured their lives in reliance on the fact that they'd be able to choose abortion, and they've chosen their careers and made their life choices on the expectation that they'd be able to exercise a right to choose. That's what the court said in 1992. But Alito said all that was wrong, and that the right questions for deciding whether a precedent should be overturned include, was the decision egregiously wrong? And does the Constitution support such a right as an original matter? So in other words, the justices should first go back and ask whether what they would have done as an original matter. And if they conclude that the court was egregiously wrong to find the right, then they should feel free to overturn it. And in addition to that, he said the test wasn't workable because the whole test is based on viability as a standard, which is around 26 weeks. And now we're talking about a 16-week ban. And he said women haven't structured their lives around this right because it's only, Alito said, a particular woman who is making decisions while she's pregnant, who's making decisions about the future. And once we overturn Roe, then women won't structure their lives in reliance on that right anymore. That was his answer to the reliance question. So I've now summarized for you the arguments that Justice Alito gave, first for concluding there's no right to abortion, and second for concluding that there's no reliance or other reason for upholding Roe as a matter of precedent, despite the fact that it's been reaffirmed 6 times and that the court said there were reliance interests that are created around it. Okay, what's the argument on the other side? What is the dissent going to look like? Well, first, the dissenters may say Justice Alito is being selective in his account of constitutional history. From the time of the founding until the 1850s, common law did protect a right to choose abortion until fetal quickening, or when you can feel a fetus moving, which takes place around 16 weeks, which is around the time of the Missouri law. So it's at least arguable that there was a tradition-based right to choose abortion from the time of the founding until the mid-1850s. And then the historical story further gets complicated by the fact that the laws that were passed restricting abortion starting around the mid-1850s were mostly championed by the All-Male Medical Association to protect the prerogatives of male doctors and to keep women in their place, to ensure that they would be mothers rather than equal citizens. And there's a lot of evidence about this in the debates over these much more restrictive Civil War era abortion laws. And here's where Justice Ginsburg comes in, abortion laws were liberalizing in the 1950s. And between 1950 and 73, about, these numbers may not be exactly right, but the number of states that banned abortion throughout pregnancy went down from 50 to 30. And Justice Ginsburg said that if the political process has been allowed to take its place, and Roe hadn't stepped in and come up with a very sweeping prohibition on abortion throughout pregnancy, she believes that the women's rights movement and the increasing liberalization of attitudes in society would have meant that many more states would have liberalized their abortion laws and allowed for abortion, especially early in pregnancy. And this is further supported by polls suggesting that even today, about 2/3 of the country supports the right to choose abortion early in pregnancy. And similarly large percentages support the right to restrict abortion late in pregnancy. And only 20% of the country supports bans on pregnancy throughout pregnancy, even in the reddest states. Now, justices don't openly cite opinion polls, but this is relevant to the tradition question as you try to discern the complicated question of whether there's a tradition of banning abortion throughout pregnancy, which arguably there is not. Although you can tell from the fact that I've had to move from citing state laws on the books to a kind of complicated history, that it's the historical question is not an open and shut case. All right, that's the historical methodology. Then we come to the right recognized in Roe itself, which was not simply a tradition-based liberty right, but also a more sweeping right of autonomy. At the heart of liberty, Justice Kennedy said, in his opinion upholding Roe, is the right to define one's own conception of meaning, the universe, and the mystery of human life, and the idea of autonomy, and the ability of individuals to make important life choices was recognized in Casey and reaffirmed in the marriage equality cases. So if you want to overturn Roe, you're also overturning that autonomy right, which is rooted not in history, but more in a kind of vision, I would call it, of natural law. It's a more sweeping form of constitutional interpretation. Conservative originalists reject it. So Justice Alito and the conservatives don't agree with this approach to the Constitution, but it's part of our law that's been reaffirmed in many cases, from Obergefell and the other gay rights decisions to Casey and other decisions upholding Roe. And third, there's the question of women's equality. And in reaffirming Roe, the court said that women have structured their life decisions and made their career choices based on an expectation of the right to choose abortion. And as Justice Ginsburg often argued, restrictions on abortion impose burdens on women that are not imposed on men. And in that sense, violate the equal protection of the laws. Now, Justice Alito dismissed that in a single sentence by citing a case called the Geduldig case, which in the 1970s said that discrimination based on pregnancy isn't a constitutional violation because it's not based on gender. It distinguishes between pregnant people and pregnant women and non-pregnant persons. So exquisite legalism. Obviously, only women can become pregnant at the moment, but the court said it's not pregnancy, it's gender that's being discriminated against, but the act of being pregnant. Now, the counter to that is that if Justice Alito and the conservatives want to overturn Roe, they could also overturn Geduldig. You know, maybe that decision was wrong, and maybe Justice Ginsburg was correct that restrictions on abortion are a violation of equal protection. There's no doubt that the dissenters will argue that. Then finally, and the fact that it's taken me a while to get through this suggests that this is a complicated case. There's the question of precedent. And I am quite confident that the liberal justices will be blistering about this question because they were in the oral argument. Justice Breyer said, look what the court said in Casey. The court's entire legitimacy is based on citizens perceiving it to be nonpartisan. And when a decision this deeply rooted in law just changes because the composition of the court changes, the court looks really political. And Justice Sotomayor was even more strong in her words. She said there's a stench of politics that hangs over the court when it considers overturning Roe. And I think the justices are going to say, hey, conservatives, you're doing this just because you have raw political power. And citizens are going to see this as a political act, and they'll be right to do that. So I think that's what I've got. I know it's unusual for me, maybe, I don't know if you were expecting this or not, but it's unusual to take the time and talk about the court to actually dig into the constitutional arguments on both sides. But I think it's very important. It's certainly in my job at the Constitution Center, because the only way that you can make a decision about what to think about the court is to evaluate these arguments on your own. If you just think, I'm pro-choice, I think the court's a bunch of conservative politicians because they overturn Roe, you're not going to see the constitutional arguments in their terms. The Justice Alito and Justice Thomas has said in interviews recently, there's not a hint of politics that ever is exchanged at the court. We only make constitutional arguments. There's no doubt that whoever joins the majority will be completely convinced in their minds that they're following the Constitution and not being swayed by politics. And the liberals will feel the opposite. And for you to make an informed decision, you've got to evaluate these arguments and make up your own mind. Okay, I think I've delighted you long enough with my with the kind of constitutional seminar. We can certainly talk about guns or religion or anything else you like, but why don't we pause, and I'd be delighted to take your questions.
So you'd like us to turn it over for questions from the audience now? Is that what you said?
Yeah, that'd be great. Unless you,
Okay.
I can keep
You
going,
actually,
but
that was very helpful. You actually, as I, prepared some potential comments, in a way, you've sort of gone over both of them. So that's very appreciative of you. Perhaps we should start with the first question. So far, it's the only question in the chat from Marty Tillman, who wonders if the Alito argument becomes the decision, that a particular right was not explicitly referenced in the Constitution. What other rights, if now challenged, would have to fall?
That's a great question, Marty Tillman. That's a very important one. And already some people who've read the Alito decision are saying, well, this means that other unenumerated rights, like the right to marriage equality and the right to use contraception by married couples, to name just two of the most prominent examples, will be overturned as well, because after all, they don't appear explicitly in the Constitution either. And both of them were justified on a broad vision of the same autonomy argument that the court recognized in Casey and it would be overturning in Dobbs. So if all that could support the right to marriage equality and the right to use contraception was the autonomy language that I quoted from Justice Kennedy, at the heart of liberty is the right to define one's own conception of meaning in the universe and the mystery of human life, then it would be correct to conclude that those decisions might well be vulnerable and be overturned. And yet, Justice Alito's draft stresses we're only talking about abortion and we're not making a judgment about other unenumerated rights. And as it happens, it is possible to justify both the right to use contraception and the right of marriage equality in narrower, more historically based ways that doesn't rely on that sweeping autonomy language and might suggest that they will not be overturned. So to be specific, let's talk about the right to use contraception, which was recognized in a case called Griswold versus Connecticut, decided in 1966. So while Justice Douglas's majority opinion did use autonomy language, in particular, he talked about a right to privacy emanating or coming from what he called penumbras formed by emanations from different parts of the Bills of Rights. And that language is very controversial, and Justice Thomas has in his chambers a sign that says, please don't emanate in my penumbras. He's kind of making fun of the loosey-goosey nature of that autonomy language. There are narrower ways of defending the right to use contraception, and they appear in Justice Harlan's concurrence. So Justice Harlan, a moderate conservative, came up with two reasons for defending the right of married couples to use contraception. First, he said it's really impossible to enforce these anti-contraceptive laws without breaking into the marital bedroom or without really enforcing really intrusive law enforcement practices. And that might violate the Fourth Amendment right to be free from unreasonable searches and seizures of the home. That definitely applies to contraception in the home. It doesn't apply to the right to abortion, which involves a fetus, and abortions don't take place ordinarily in the home, although the abortion pill might complicate that question. But you could have a Fourth Amendment argument. But the narrowest justification for the right to use contraception in 1966 was the tradition-based argument. In 1966, Connecticut was the only state in the country that banned the use of contraception by married couples. It was a vestige of a 19th century law still supported by the Catholic Church, but all the other states had repealed their contraceptive bans if they had them. So if you take that history and tradition argument that I started off with, Griswold is a no-brainer. It's one state against 49, if there were 49 states in the Union in 66 or however many states it was. That was an easy case for there being an unenumerated deep liberty deeply rooted in the traditions of the country. It's a far stronger case on historical grounds than Roe. So you could say, if you buy that historical argument, Griswold is safe, even if you overturn Roe. And what about marriage equality? That seems trickier because obviously there's no deeply rooted tradition of gay people being allowed to marry. But if you view the right to marriage itself as a right deeply rooted in tradition, as undoubtedly it was and is and had been part of state common law since the founding, you could say in a kind of straightforward way that if a right is fundamental and deeply rooted, then it has to go to everyone on equal terms. Now, the counter is it only went to men and women. And the counter to that is that distinction is not justified. It's a gender-based discrimination. Men can marry men and women can marry women, but men can marry women, women can marry men, but men can't marry men. Now already you're getting a little fancy. You're getting away from the simple historical argument. And you also have to somehow, if you're a conservative, narrow the definition of marriage to marriage between two people rather than polygamous or multiple marriage. So that's why the marriage arguments seem a little more vulnerable than the contraception arguments. But if I had to predict, and my predictions are worth what you're paying for, there's a decent chance that a court that overturned Roe might not overturn the marriage equality decisions, not least of which is the fact that they're overwhelmingly accepted by liberals and conservatives, especially young people, where young Republicans are just as likely to support marriage equality as young Democrats, and that has been very much embraced by the country. So even if the tradition argument takes account, even in an unspoken way, of the divisiveness of the question in the country as a whole, marriage equality is not divisive at all anymore. It's been very broadly accepted, unlike abortion. So that's the beginning of an answer to your excellent question, Marty Tillman. I mean, it all depends on which methodology you embrace, which of the constitutional methodologies, which is why at GW and at the Constitution Center, I'm a real evangelist for citizens who aren't lawyers learning the constitutional methodologies that I've been talking about. First, text. Second, original understanding. What did the founders think? Third, tradition. What's been the tradition of the states over the course of American history? Fourth, precedent. What has the court said before? Fifth, prudence and pragmatism. What is judicial legitimacy counsel and what are the costs and benefits? Sixth, natural law and moral philosophy. Those methodologies, they're all online at the National Constitution Center's amazing interactive constitution. And I waited for a bit in my talk to call your attention to this astonishing website, which has gotten 60 million hits since we launched in 2015 and is now among the most Googled constitutions in the world. But here it is. It's constitutioncenter.org. And you can click on any provision of the Constitution. Let's pick the First Amendment. Well, let's pick the Second Amendment because I'm sure you guys want to hear about that too. And you can find the leading liberal and conservative scholars in America, nominated by the Conservative Federalist Society and the Progressive American Constitution Society, with 1,000 words about what they believe the core of the Second Amendment means, which is right here. And then separate statements, that's called the common interpretation, separate statements in this matters for debate about what they disagree about. And Winkler and Lund agreed that the Second Amendment at its core was, look at this great paragraph because it sums up the consensus meaning of the Second Amendment. Implicit in the debate between Federalists and Anti-Federalists were two shared assumptions. First, that the proposed Constitution gave the federal government almost total legal authority over the army and militia. Second, that the federal government should not have any authority at all to disarm the citizenry. They disagreed only about whether an armed populace could adequately deter federal oppression. So it was an effort to stop the federal government from taking away people's liberty. That was the core view. But then Nelson and Lund disagree about assault weapons bans, with Lund saying that you can't ban assault weapons because there's no closed class of assault weapons, that calling assault weapons a particular kind of rifle is like calling French fries freedom fries. And here we go. Popular bans on so-called assault rifles, for example, define this class of guns in terms of cosmetic features, leaving functionally identical semi-automatic rifles to circulate freely. This is unconstitutional for the same reason that it would violate the First Amendment to ban words that have a French etymology, or to require French fries be called freedom fries. And Lund disagrees and says you can certainly define assault weapons in a clear way that is not overly broad. And lower courts have tended to uphold assault weapons bans, although one California district court just struck them down. And in addition to this marvelous feature, the interactive Constitution has all of the podcasts and videos that the Constitution Center produces pegged to the various constitutional provisions at issue, look at these phenomenal topics that we've been doing recently. Just yesterday, we posted this great history of free speech with a wonderful scholar who's written a book on the history of dissent, Jacob Meshingamba and David Cole from the ACLU. We had a talk about social media regulation with Republican and Democratic attorneys general, the campaign finance cases, guns and abortion discussion with an incredible array of scholars, Melissa Murray of NYU, Keela Marr, Clark Neely, Kimberly Storr, and David French. Friends, what's so crucial about what we're doing, which I believe is kind of a radical act in these polarized times, is bringing together people who disagree for these civil dialogues. And it's so inspiring to hear vigorous disagreement in the most civil and engaged way. And it really is a model for what is necessary if this republic is going to survive. And just taking the time to bring these folks together seems like a radical act of faith in the American ideal. And there's so much content here. They're historical, they're contemporary. And then there are these great educational videos that we're teaching for middle and high school kids, Constitution 101 classes, where every week we jump on a Zoom and teach the essence of the Constitution. And in July, we're posting a 15-week Constitution 101 core curriculum with 15 modules on free speech and the Second Amendment and the history of slavery and the civil rights movement, as well as this amazing founders library of primary texts from the documents that inspired the founders' understanding of the pursuit of happiness to Frederick Douglass to Martin Luther King. There's something so empowering about putting the primary texts up and helping students of all ages learn from them. And it's just going to be a transformative thing. So as you can see, I'm very keen as an evangelist for this great free educational tool. I'd love you to use it and learn from it. And back to your question, and I'll wrap up, Marty Tillman, I think to really be informed about these cases, you got to read the decisions, first of all, the majority opinions and the dissents, and you've got to learn a little bit about these methodologies that you can all learn about online on the Interactive Constitution, so that you can choose which methodologies you think are most persuasive and make up your own mind.
Well, that's a wonderful resource. That it looks like it would answer a number of the questions that are in the chat that we may not get to today. I'd like to turn to the confirmation process, because that's another question that's on a lot of people's minds, including in the chat. I'd like to start with my own question on that, which is, should we expect in the future it will be the norm that if the president is of a different party than the majority of the Senate, that Supreme Court justices will not be confirmed, not even be considered? The nominations won't be processed.
Yes, I think the answer is yes. I think at this point, unless the president controls the Senate, he or she cannot get a nominee through. And what should we do about that? I don't know. That's beyond my pay grade. We are in a very polarized moment in American politics, and this is the way it is. And we can wish it to be otherwise, but it's not. So
that's quite discouraging, isn't it? And the Supreme Court then could be operating with far fewer than 9 people during the course of various presidencies.
It could. I mean, one thing, I don't know if it's consoling, but it's illuminating, is to look at history and to recognize that things have been very polarized before. In particular, you know, when the election of 1800, which was almost as there was mob violence, and it was almost as contentious as this, or it was equally not clear that the Republic would persevere. It persevered largely because Adams accepted the results. He stepped aside, he left. He was grudging about it. He didn't attend Jefferson's inaugural, but he accepted the results. But the outgoing Federalists changed the size of the court to deny the incoming Jeffersonians the power to make appointments. They canceled the Supreme Court term for 2 years. And when Marshall decided Marbury, he also decided a case called Stewart and Laird, where he agreed that Congress had the power to cancel the Supreme Court term, because he knew that if he came out the other way, that Jefferson would have ignored him, and he would have appeared to be a paper tiger. He would have, as Marshall said, I'm not fond of butting my head in against a wall in sport. He didn't like to fight battles he couldn't win. So, and it took a couple years for the new Congress, which eventually became Republican, to restore the size of the court. And the number of justices kind of fluctuated between 6 and 9. During the Civil War, it was briefly up to 10 when Congress added a circuit. But then the Reconstruction Congress so mistrusted Andrew Johnson that it let the number sink below 9 because they didn't want him to make any appointments. And then once he was out, it came back to 9 and settled there around the early 1870s, and has stayed there ever since. So when I was in law school, I was kind of surprised that Congress actually had the power to change the size of the court and could do so for political reasons, because it seemed like a violation of the separation of powers, but it's not. History unequivocally says Congress can manipulate the size of the court for political reasons or any other reason, and it could happen again.
So that leads to a question about the recent study done by a presidential commission about the court, and coupled, so I'd like you to give us some comments about the commission's report from your perspective. And then I'm wondering whether you can think of any ways, well, perhaps you've already mentioned some, that changes can be made without amending the Constitution.
The commission report is very thoughtful and is worth reading. The commission didn't endorse particular reforms in most cases. It famously took no position on court packing. There was a division of views on that, but it thoughtfully set out both the history of court packing and the arguments on both sides. I think it did gently suggest in a very subtle way that court packing would encourage tit for tat retaliation and would lead the size of the court to balloon and change for political reasons, and kind of was not a fan of it for that reason, but it didn't do so explicitly. But the commission does endorse a few reforms, in particular an ethics code for the justices, and it expresses concern about the so-called shadow docket, where the court is deciding important cases without the benefit of full briefing and arguments, and suggests that at the very least decisions on the shadow docket shouldn't have precedential effect. In other words, lower courts shouldn't be able to cite them, and generally suggests that the justices should try to hear arguments if they can, even on an expedited basis. And the court may have taken some of this to heart, because it's been, since then, there were a couple of cases that it heard fast, including some of the COVID-related cases, where it would agree to hear the case, schedule arguments, and decide it all within the matter of a month or two, which is far faster than the norm. So although the commission was either dismissed by extreme partisans on both sides who wanted it to take strong views, or ignored by most people who found it, long and technical and weren't moved to read it, download it and skim it, because there's a lot of meat in it, and it was very thoughtful, and it was a really good group, and I'm a fan of the report. Are there other changes that could take place without amending the Constitution? Well, there are the most important way to protect rights that doesn't involve constitutional amendments are state and federal laws. So if Roe is overturned, as you all know, I think by now, it's not that abortion becomes legal or illegal everywhere, but it's up to the states to decide, state by state. And blue states will protect or expand their protection for abortion, and red states may well restrict abortion dramatically. Right now, there are not many clinics in red states, as you know, which is why the late Justice Ginsburg told me repeatedly, first she thought Roe would be affirmed as long as Chief Justice Roberts were the swing vote and she were on the court. She expected him to uphold Roe. Of course, that's not the way things worked out. And if Roe is overturned, she said the burden would be felt most by poor women who would have trouble getting access to clinics. And she supported giving poor women access to clinics paying for transportation to other states where abortion was available and doing other things that would ensure equal abortion access that didn't discriminate on the basis of wealth. There's going to be a big debate about whether there should be a federal law. Remember that it could go either way. You could have a federal law, and in fact, Congress came within a few votes of passing it in 1992, and the Dems had the votes to do it, but they were too reliant on the court and didn't pass the law. It would have required just protecting early term choice and not extending protections throughout pregnancy. But had the court codified Casey in 92, we wouldn't be having this discussion. Now, of course, you need 2/3. You need a filibuster-proof majority, and that does not exist when it comes to abortion. But that's, you might say, is a good thing if you're a pro-choice person, because a Republican Congress might try to pass a law banning abortion throughout the country and saying that life begins at conception. And that would dramatically transform the state of our abortion laws and would mean that you couldn't get access to abortion even in blue states that wanted to protect it. Now, that's not going to pass either as long as Congress doesn't eliminate the filibuster. So that's a good reason for keeping the filibuster if you're pro-choice. So that's one place to start. And I'll just say on the constitutional amendment front, although an amendment is unlikely in practice to pass because you need two-thirds of both houses of Congress to call a convention, or you need it to be proposed by 2/3 of both houses of Congress. So you have the same filibuster-proof majority problem. The Constitution Center recently hosted a constitutional mini convention exercise where we convened 3 teams, libertarian, progressive, and conservative, to hold their own conventions in a state of nature or state of Zoom or whatever it was. And then they came back and compared amendments. And to our tremendous surprise, we found that the conservative and progressive teams had each proposed 2 of the nearly identical amendments, namely term limits for justices of 18 years and replacing the Electoral College with a national popular vote. And it was so interesting to find that agreement, because they came up with those amendments without talking to each other, that we're reconvening them and we're going to bring them together at the NCC and in Zoom land again to see if they can come up with language for proposing actual amendments. Even if they do that, that suggests that at least among the law professor set, these are very distinguished law professors, there is some agreement on these reforms. Hard to get them through the amendment process for the reasons we've discussed, which is why the late Justice Scalia thought that amendments should be easier to pass than they are, but that would take an amendment, which is unlikely.
Well, you've answered a number of questions there. I'd like to go back to a question that's on some people's mind, and that is about if you have insights into how Justice Ginsburg, I know you were very close to her, and again, your book is very, very interesting. So if you want to make a plug for it, please do. Conversations with RBG. But do you think she would have decided Roe v. Wade differently had she been on the court when that case was before the court?
Yes, she would have. She talked about it extensively. Her approach, which was visionary, was based in women's equality, not the right to privacy. She argued a case called the Struck case, Susan Struck case, which she does discuss in our interviews. I'll see if I can find it to quote from her beautiful words, which are so sacred always. And so she chose her words so carefully. And in her Struck brief, she noted that, quote, individual privacy with respect to procreation and intimate personal relations is a right firmly embedded in this nation's tradition and in the court. But she also said that the regulation in Struck, which required all women in the Air Force to be discharged as soon as they became pregnant, was a form of unconstitutional sex discrimination because it treated pregnancy far more harshly than it treated other temporary disabilities affecting men. The case became moot. In other words, it was no longer an active case, and therefore the court never heard it, and Ginsburg wasn't able to convince the court to adopt her views, but she cared so much about the Struck case, and she gave the Constitution Center a signed copy of her brief in the Struck case, and had the court adopted her reasoning, then the right to abortion would be based on women's equality, not the right to privacy. And she criticized Roe for being too sweeping. She thought that the court should just have struck down the extreme Texas law at issue, which had no exceptions, including for the life of the mother, but not come up with regulations for late-term abortions. But as she told me many times, that she thought the result in Roe was absolutely right, that that Texas law was unconstitutional, and had the right to choose been based on women's equality, it would have been more enduring. The court in Casey has some women's equality language, and there's Justice Ginsburg and her dissent from Justice Kennedy's decision to uphold partial birth abortion laws had a very strong defense of women's equality. But it's unfortunate that the women's equality argument was never more fully developed by RBG on the court. She didn't have the chance to do it because if it had been, the right to choose abortion might be more secure.
A question that lingers with everybody is, maybe you have some insights into that, as to why she didn't retire earlier while Obama was president.
Well, I asked her that too, and let me
Oh.
quote from her language there. One of the many marvelous things about Justice Ginsburg, this great hero, she chose her words so carefully. And when I sent her transcripts of the interviews, she was ill then, and I didn't even know if she'd have a chance to review them. And in 20, I guess it was 19, 10 minutes after the Supreme Court term ended, she emailed me and said, I have your manuscript and I will give it to you on Monday. And I was stunned. She'd been ill. She was on the court. I didn't even know she'd get to it. And I showed up at the court the following week. She handed me the manuscript, and each page was marked up in her beautiful pencil. And I was stunned. I said, when did you have the time to do this? Well, I did it in cars, and when I was in the hospital, and when it was right before the opera started. But you had all these other responsibilities. How did you have time? Well, I said that I would do this, and I'd like to do what I say. Her work ethic was so extraordinary, and her total focus and devotion to having each word that went out in her name be precise, so overwhelmingly intense, that she found time for this among all of her other responsibilities. She's just an incredible inspiration to me and millions every day, and I hope to you, about how much can be achieved by overcoming unproductive emotions. She said her mother always told her to overcome unproductive emotions like anger, jealousy, and fear. They will distract you from productive work. And if you can tune in and focus on the task at hand and not allow yourself to be distracted, you can change the world, as she did. She was the most focused, productive, disciplined, and heroic individual I've ever had the privilege of knowing. And this is just one example of it. But here's what she said when I asked her that question. I said, in 2014, I said, speaking of retirements, there are some who say that you should have stepped down earlier when the political landscape was more favorable to the Democrats. How do these suggestions make you feel, and what's your response? RBG. First, I should say I'm fantastically lucky that I'm in a system without a compulsory retirement age. And then she said some other stuff, but then she concluded, I asked some people, particularly the academics, who said I should have stepped down when President Obama was in office. Who do you think the president could nominate and get through the current Senate that you would rather see on the court than me? No one has given me an answer to that question. So that was her answer. She didn't think that the Senate would confirm anyone better. And although the timing is delicate, and it's always impossible for us to know the limits of our own mortality, and she did everything she could, and she was trying so hard to hold on. It's so incredibly moving and ultimately tragic that she missed her goal by just a few weeks because her body
Yeah.
gave out. You know, during the times when people were calling for retirement, I think the Senate was Republican and she thought no one would get through. And given what happened to Merrick Garland, maybe she was right. So that was her response.
Right. Yeah. Well, thank you very much. You've given us the hour you promised to give us. There's a few more questions. Are you interested in any more, or should we bring this to a close? And before you answer that, I just want to mention that that Ira of Washington Hebrew staff has put in the chat a link to where one can find your book, Conversations with RBG.
Thank you so much for that. I think on the Jane Austen theory that I have delighted you long enough, maybe I'll leave you hopefully wanting more, but you know, all of you now, I hope will perhaps be inspired to learn more on your own. And it's such a meaningful thing to learn about the Constitution. And this is my hope for you, my takeaway, my challenge. We're about to, these decisions are going to come down and the country's going to explode. And both sides are going to be very passionate. And I understand that because these are seismic shifts. But try to evaluate them in a deliberate way by doing just what I said. And the very basic thing I'd love you to do is read the decisions. Read the majority opinions, the concurrences, and the dissents. I know many of you are not lawyers. Hopefully, congratulations on that distinction. But you don't have to be a lawyer to read a Supreme Court decision. Read it as a citizen. You can kind of skim the procedural stuff. There's some jargon about how the case got there and who the parties are. You don't have to read that stuff carefully. But I know as good focused readers, you'll quickly get to the heart of the matter. And that Alito decision, after the procedural stuff, you can understand it and evaluate those arguments. And then read those dissents. And they're going to be written for you. Justice Kagan, Justice Sotomayor, Justice Breyer will be giving you reasons that they hope will persuade you. And read those and make up your own mind and open your minds to the possibility that you might, as I said, reach a constitutional conclusion that differs from your political one. And then you'll be thinking like judges and you'll be acting like citizens, which is what the founders hope. And you'll be learning and growing. And that's ultimately what all of us have to do together. The core definition of the pursuit of happiness, according to the founders, was to be a lifelong learner and to spend each day reading deeply and thinking and expanding your mind and learning and growing together. And all of that power is at our fingertips in this internet age when there's so many distractions and so many ways to fritter away time on Facebook and Instagram or whatever else your, frittering platform is. I always ask myself, what would RBG do? And I think of her, even in her illness, focused, reading, devoted to her work so that she could be her best self and serve others and make a contribution. And I think if she could do it, even as her strength was failing, we can too. So, and then I try to set aside the Facebook and pick up a book or read a text or write and teach. And it's very fulfilling and it'll make you learn and grow and happy. So, and then we can all say to ourselves, Mazel Tov, we're lifelong learners. It's wonderful to connect to you, friends. I'm right in the neighborhood, so I'm so glad to meet this great community. And thank you for having me. I think you're muted, Jen.
Oh, I'm sorry, muted. You're so inspirational. Thank you. When should we expect these blockbuster decisions that we're anxiously awaiting from the court? Do they definitely come out in June?
There's never a firm prediction for the court, except they'll be out by the last day of the term, and the last day of the term historically, has always been basically the last day in June. I don't think it's gone into July for a long time. So they're likely to be out by the end of June, but anything is possible.
Are there some other cases pending for next year that look like blockbuster cases?
Well, yes, there certainly are. And the big one is affirmative action. where the court is. I'm not giving predictions.
So we're talking about case that
anywhere,
affected
but-
my law school, Michigan Law School, right?
Well, it's Harvard in this case, Harvard and UNC, and the court is likely to strike down affirmative action at Harvard and UNC, and to say that you cannot have openly race conscious admissions. That is what is on the horizon for next year, among other things.
Okay, well, sooner than next year is a few days from now. I see that you're scheduled to speak to the Cosmos Club, of which I'm a member, about the pursuit of happiness, which you've just given us a teaser of what that will be about. Unfortunately, I'll still be at the beach when you're talking, and it won't be on Zoom, but they do record it, so I'll be sure to catch it later. So thank you so very much. You've been really inspirational, and in a way, you've turned us all into potential justices of the Supreme Court. Okay,
That's
Thank
the
you
goal.
so much.
Thank you all. Have a good weekend.
well, I think this has been very inspiring, if not somewhat pessimistic in outlook. I want to thank everybody for participating and for attending this morning, and wish you all a wonderful day.